afternoon, everybody, and thank you for joining today's session. As you obviously know, today's session is on the Startup India initiative, which is a initiative which was launched by the government a few months ago, earlier this year. And the Startup India initiative, while we are going to primarily speak about the specific initiative of the government which was launched, we will also talk about some of the other startup related initiatives that have been taken in recent times, which have a direct impact on the various businesses in India. We are also going to briefly talk about the MSME Act and compliances thereunder, and then we'll be happy to take any questions. Today I'm joined by my colleague Zahir Tanavdar, who will be primarily taking the session. Zahir is a lawyer with over 10 years of experience and has been working closely with Explosion on various Startup India related initiatives. So as you probably know, while the definition of startup has always been fairly ambiguous, and there have been differences of opinion as to whether for example, is Flipkart still a startup, or is housing.com a startup? When does one stop being a startup, and when does it become a full-fledged organization? I think for the first time the government of India has tried to put some parameters around the term startup under the Startup India initiative. Obviously, whether that is beneficial or whether that's blinkered the concept of startup too much is something that will be discussed in as we move on. Broadly speaking, in the last Independence Day speech of 2015, the Prime Minister of India had launched the Startup India initiative, or talked about the Startup India initiative in the form of an announcement, stating that it's for fostering entrepreneurship and promoting innovation. It was targeted for India to become a nation of job creators and fostering a fruitful culture of innovation in a country in a long and important journey. The Startup India, the initiative itself was formally launched on 16th of January. Through an innovation, startup which was held in Delhi. Some of us were fortunate to be a part of that, session. It provides a platform to bring together all stakeholders, stimulate dialogue on key challenges that the Indian innovation ecosystem currently faces, and provide the potential solution to address them. So now we can get into, so essentially the purpose, of course, of setting up the Startup India initiative was to ensure that we build the ecosystem that is required to be able to globally compete. There was a feeling that a lot of Indian entrepreneurs were getting, were not getting adequate incentive to start their ventures out of India, and were taking away their ventures to other countries like Singapore and the US and sometimes even Europe. And it was felt that it was important to encourage these startups to be housed and grow out of India in the longer term interest of the country. So what the Startup India initiative has done is put some thresholds around who would be considered a startup. So first of all, the important point is that proprietorship firms, for example, cannot be considered a startup. So it has to be either a private limited company, or a registered partnership firm, or a limited liability partnership, or LLP. Of course, private limited company could even include a one-person company, a concept which has been introduced under the 2013 Act. The maximum age of the startup could be 5 years. It's an either or, so it could either be 5 years or a turnover limit of 25 crores at the end of the financial year. So if a startup has crossed either of the two thresholds, which is if it's either more than 5 years old, or if it has over 25 crores of revenue in a particular financial year, it will immediately lose the benefits of being a startup. But beyond these two, there's a third parameter which has been set, which particularly has been criticized by some sections. And this says that it's the operation of the startup has to be such that it is working towards innovation, development, deployment, or commercialization of new products, processes, or services driven by technology or intellectual property. So a lot of businesses which are starting up now, but aren't necessarily doing something which is completely innovative. And obviously, there is always a debate about what is innovation, whether if there is an existing e-commerce company somewhere in the world, and if a second e-commerce company in a similar space is set up in India, will that be considered to be an innovative company? Would that technology be considered to be technology which is being used towards innovation? Would it be considered a new product? Those are questions which have not been clearly answered as of now. As a result of which, it is still not quite sure, and these are obviously early days. And while some applications have been submitted to be registered as startups, only a few have got registered as on date. So it is still debatable as to how the government will view such situations. But essentially, these are the restrictions which have been put. So an entity formed by the splitting or reconstruction of an existing business shall not be considered to be a startup. So this is, of course, understandable. So suddenly, if a large enterprise splits itself up or creates a subsidiary and starts doing pretty much what they're doing currently, that will not be considered a startup or will not be able to get the benefits under the Startup India program. So that is essentially the basis of a startup, or the definition of startup. Post this initial policy document, there have been several documents that have been created, and all of them which deal with benefits and privileges to the startup community. And in each of them, startup has been, the reference has been drawn to this specific policy document to understand the definition of a startup. So the definition of startup is now pretty much set by this, unless it is subsequently changed basis various feedback that is being sent. This is now the definition of startup, which will be used for giving all benefits. I will now pass on to Zahir, my colleague, who will start talking to you about the procedure for registering a startup, which has been laid down.
Thank you, Indranil. Hello and good afternoon to everyone. Like Indranil pointed out in the previous slide, in order to become a startup, you can either be a private registered company, a private limited company, a registered law firm, or an LLP. Now, there are two options in which you can register yourself. An entity can register itself as a startup. Of course, the first is if a company is already existing. In option 2 in the slide, it's shown that if a company or a firm is already registered, it can go into the startup portal or the mobile app and opt for the registration. The first option is for an entity, keeping in mind for an entity which is not existing as on date. So for that, first you need to register yourself as a private limited company or with the registrar of firms as LLP or a partnership. And then as you take up option 2, which is registering yourself as a startup by moving into the startup portal or the mobile app. Now, there are various other documents, a set of documents, in fact, which are options. So there are or everything is connected with an or. So any one of the documents is required to be provided along with the application which you make in the portal. Now, the first one, there are a set of recommendations from the incubators which you need to obtain. Now, in a format which is, of course, specified by the Department of Industrial Policy and Promotion, DIPP, the incubator has to be either established in a postgraduate college, or it has to be funded by the Government of India or any state government as part of a specified scheme which is aimed at promoting innovation in India. Another thing you can, as an option, you can also provide a letter of funding of not less than 20% in equity by various fund houses like an incubation fund or an angel fund, private equity fund. again, which are registered by the SEBI, and those of which endorse the innovative nature of business only. So these angel funds or the fund houses, they typically should be funding the innovative businesses which are doing innovative nature of things.
And what is interesting to note is that the government is not just saying that you apply and we will come in and tell you whether we consider you to be innovative or not. It is allowing incubators, and incubators are essentially the government is also encouraging new incubators to be formed, and there are incubators that several large multinational corporations which are in the technology space are running on their own. There are various Indian Institutes of Technology, Indian Institute of Management, which are running incubators as well. And then there are, of course, government-run incubators as well. So any of these could also be endorsing your application and endorsing the fact that what you're doing is innovative in nature, and that would be considered to be adequate for the purposes of application by the government as well.
Right. Thank you, Indranil. Now, the list of all registered incubators and the funds which are registered with the SEBI, all are put up in the Startup India portal, which can be accessed from the portal itself. Now, besides this, there is another option. So, if you are opting for any product which is which can be protected by intellectual property, the patent which you have filed or published in the journal in Indian Patent Office can also be provided as a supporting document while making an application to register as startup. Besides this, what is obligatory, what is a must for every entity while they apply for becoming a startup is a valid PAN existing in the name of the entity. Now, besides many other things which the government has come up after this initial notification or defining what a startup means, the first and foremost would be various tax benefits which a startup can avail. Now, at the time of registering as a startup, there is an option where you can choose. There is a question basically in the startup portal which asks, do you want to avail tax benefits? Now, as a person who is registering in the portal, one has to select a yes for the application to be processed and your application to be assessed by the interministerial board, which has been formed pursuant to the notification of startup in February 2016. So as a next step, what happens is this interministerial board consisting of members who have been elected to that board, they scrutinize your application, and once they certify that you are eligible to get tax benefits, you can avail of the tax benefits which are given to a startup.
And what would be interesting to note, Zahir, is that the interministerial board consists of the Joint Secretary to the Department of Industrial Policy and Promotion, which is basically the DIPP, a representative of the Department of Science and Technology, and a representative of the Department of Biotechnology. So what is quite clear is that the people who the government's focus is clearly on scientific and biotechnological innovation as the starting point for identifying organizations which would be considered for a registration with the startup as well as for the purposes of considering them for tax benefits. And obviously one of the most critical benefits that a startup would be looking for is the tax benefit. And as people who are working in this space, one of the feedbacks that we have been receiving with regard to this particular Startup India initiative is that because of the period within which the tax benefit is available, and if you see the definition of a startup, it is only the first 5 years of a company's existence or a business's existence, or 25 crores, whichever is earlier. Now, if a company has already reached a revenue level of 25 crores and is profitable, it would be only fair that the tax benefits are taken away. But in many cases, what actually happens is that a company takes much longer than 5 years to start making profits and really getting really requiring the tax benefits. And if it's restricted to that 5 year period because of the definition of startup, what a lot of the people in the startup community are feeling is that it will not really be a genuine benefit which will encourage or which will motivate startups to stop going away from India to other jurisdictions to set up, because the similar or better tax benefits are available for many of these outside of India. And with the business structures as they are, with the maybe in the seventh or eighth or ninth year, if they don't start getting the benefits of this, there might not be adequate initiative to keep themselves registered and really move towards bringing back their business to India. Over to you, Zahir.
Right. Thanks, Indranil. What two things which, of course, another thing which has to be kept in mind here. So the period, like Indranil was pointed out, so it tells that the startups who are incorporated between 1st of April 2016 and up to 1st of April 2019 shall only be eligible to obtain tax benefits after registering as a startup.
So, which is also something that we need to consider as a potential problem, because essentially all companies, all businesses which have been formed prior to the launching of the startup initiative, which is any business which was, say, incorporated in 2015, even in December, or 2016 January, just by virtue of the fact that they were incorporated prior to 1st of April 2016, will not be able to avail of any of the benefits, which obviously is something which is not being considered in a positive way. This is inevitably going to force people to stop their existing organizations if they've started in the last 6 to 8 months and recreate another business, which again, is cost ineffective and makes limited sense. And therefore, maybe there is an opportunity to relook at some of this and consider allowing organizations which have been set up, say, 2 or 3 years ago, but who are still within that 5 year potential threshold, 5 year 25 crore threshold, to also get the benefits of the Startup India initiative.
Right. And also, we discussed in the beginning, so it's an either or situation. So the term within which you remain to be a startup, continue to be a startup, is 5 years from the date of your incorporation, or whenever your turnover for any financial year crosses rupees 25 crore. So as soon as any of them happen, you cease to be a startup, and you are required to intimate the DIPP of such incident within 21 days. Now we will move on to more specific benefits which have been given to startup pursuant to this change which is there. So first up, we will discuss what are the exemptions which are there under labor laws. So, like, as you know, there are various labor laws which apply to any entity, starting from a central level or a state level or a central act read with various state enactments. Now, what benefit has been given under the labor laws is they have listed around 9 laws. They have listed 9 laws under which certain benefits in terms of your registration requirements, your flexibility to submit online self-declaration, removing inspection for the first year while you register as a startup, and also it extends to the second and third years, from the second year up to 3 years, inspection will only be done on the basis of credible written complaint filed, and only after receiving an approval from a senior officer. So in case you register as a startup, so these are the benefits which you get under labor law.
So what we notice is that the primary benefit is of not having to bear the brunt of inspection in the initial period. So there is a fair amount of self-certification which is being allowed in the first year. But if we look at some of these enactments, for example, we see enactments like Payment of Gratuity Act. Now, as we probably know, gratuity becomes applicable only if an employee has been working with the company for around 5 years, so 4.5 years and a little more. Now, this therefore is not really such a big benefit, because it is unlikely that the Payment of Gratuity Act will even come into play for a business which is in its first year of inception. So similarly, if you look at Contract Labor Act, if you are unless your business is that of contracting people, or providing providing people to third party entities, this will not be of particular relevance, because it's unlikely that a business which has just been set up will have more than 20 or more contractors working there, which is when they will become a principal employer, and therefore the Contract Labor Act becomes applicable to them. And therefore, acts like the Interstate Migrant Workmen, or even the Trade Union Act or the Industrial Dispute Act, keeping in mind that we are talking about startups which are technologically innovative, which is creating intellectual property, it is very unlikely that a lot of these enactments will actually be relevant to them. What will be relevant is probably the EPF, the Provident Fund Act. That too, probably not so much in the first year, unless they are coming in with a lot of people right up front, because the PF Act applies if you have more than 20 or more employees. But sure, but in the second or third year, it can be of relevance. The ESI Act, if you have employees below a certain remuneration, becomes relevant. So to that extent, there is an advantage. But for most of these companies, the way startup is defined, these are likely to be technology-intensive companies, companies which are probably more into software product development, into providing solutions which are innovative. And the Industrial Disputes Act, or the Trade Union Act, or even the Building and Other Construction Workers Act, these are not enactments which are very, very likely to apply to them, at least in the initial period of their existence. So therefore, while this is definitely of some benefit to to some organizations, unless the definition of startup is made wider, the real benefits of these labor exemptions that Zahir was talking about are unlikely to be felt, or the impact of this is unlikely to be felt, or this will probably, in the short term at least, not be again enough reason for somebody who has an option of starting a business and registering it in India or registering it in Singapore. For them to choose India over Singapore, the benefits have to be a lot more tangible than something like what is offered under the labor benefits here. If the requirement for filings and registrations could also apply to things like, for example, if you allowed a startup not to have to seek a shops and establishment registration, or if you could allow a startup in states which require trade license to not require a trade license for the first 12 months, if you allowed them to operate from anywhere, including their house or their garage, without requiring any specific registration, that probably would be a more tangible benefit. Because today, as we see, many young people, maybe just two friends come together and they start their business from their house or from their garage, and if that has to happen, and if there is a requirement for that garage to get registered under the Shops Establishment Act, that becomes a problem. If those are the things that where benefits could be given, that probably would be considered to be more tangible by startups, or the kind of startups which have been defined under the Startup India initiative. The other benefit that is mentioned out there is with regard to the Apprentices Act. There is again some incentive, which anyway the Apprentices Act I think generally has been made more interesting now. But there are specific benefits which are provided of self-certification of startups and filing of a single return as with regard to apprentices, which is again something which might not be of that much relevance initially, but might be of relevance as organizations grow a little more. Over to Zahid.
Likewise, some states like Gujarat, Telangana, Karnataka, and Rajasthan, Kerala have been asked to set up policies relating to labor law so that those can be tested. They can be tested on the ground on various startups in working in those starting functions in those states, and which can be used as an example to see how good or bad exemptions are actually panning out when they're really tested on the ground level. And we all know that there is this Insolvency and Bankruptcy Code 2016, which is talked about a lot now. So there are some faster exit options which are provided to startups under that code. So winding up with regard to startups, it says that from the date of application by certain debtors, companies who can wound up within 90 days from the date of application. Now again, the definition of those are not very clear, because the government says that the type of companies who will be allowed to exit within those 90 days have to be notified by the central government. On that part also, it is not very clear like which companies will be able to take this exemption. Now, again, appointment under the same code, appointment of insolvency professionals who will assess the insolvency of the company which it has attained, and so that to ease out to make the process of winding up very swift will be in place once the rules particularly come into force, making these provisions of the new code, the bankruptcy code, more clear.
Probably what is most important from the startup perspective are the tax benefits that are available. But if you have been following the news with regard to tax exemptions, you will probably know that many of the organizations which have actually applied for tax exemptions under the under the Startup India program have not been granted the tax exemption. So for various reasons, they have failed to meet the standards that have been set. But basically, the tax benefits will be primarily with regard to certain benefits that they get within a period of the first 5 years. So they can claim the benefit, or they will be, their income tax will not have to be paid particularly, which is the main benefit. They can choose any 3 years during the first 5 years when they will not have to, when they can claim zero tax, even if there is a profit. So obviously there again, there is an issue. Like we discussed, in the first year, it's unlikely that you would have made a lot of profit. But assuming that you've made some profit, should you wait and not seek benefit? Because the benefit is available for any 3 years during the 5-year period. Now, if that is the case, the question will be, do we wait for the second year when you will make more profit and therefore gain better tax benefits, or should you claim the tax benefit right away? This is something which is again being discussed, and there are no clear guidelines or clear understanding on these issues. These are early days, and this is something that is again being discussed at great length.
So now the first thing which is there is tax benefits for startups while they are applying for registration. Next thing is they can, capital gains exemption is there for startups for capital gains which is invested in startup fund. received from the government. Again, exemption of paying tax, like Indran pointed out, from paying tax as capital gains if it is used for purchase of new asset, and consideration of fair shares exceeding fair market value. So any shares which is exceeding the fair market value as taxable under income from other sources will not be levied on investment by venture capital funds and incubators in startup.
And this is something that, if for people who have been following the startup ecosystem, it is something that has had in between become a serious source of concern, because oftentimes the what should be the fair market value of a company which has just come into being, and which is probably still in the early stages of development of a product which has not even been taken to market. So if a large global venture capital fund comes in and values it at $100 million, there is no real way of calculating the fair market value for a company of that sort. And a lot of times the question therefore was that if shares were issued at that price, would that be considered to be a benefit to the venture capital fund, or could it be considered that they will have to pay tax on that kind of, if they were issued a certain number of shares and then subsequently were issued more shares within a certain period of time? What has happened is that has now been given a specific leeway under the tax exemption scheme for startups.
Right. So extending MSME benefits to startup, how that is done. So tax exemption to newly formed manufacturing MSMEs, they have been given a tax exemption if, again, capital gains is used to purchase new asset. So the same set of benefits which are given to MSMEs shall be extended to startups also. Again, it has to be a manufacturing MSME, like we discussed in the definition also. Now, any product which it manufactures has to be towards innovation or which can be protected by intellectual property. Those things remain. The last point, Engineer has already discussed, the period of 3 years, which is the exemption. You have to decide within those 5 years which are the 3 years for which you need tax exemption. Now again, for a startup, there are certain listing relaxations which have been provided by SEBI. Like Indranil was pointing out during our slide on labor law exemptions, what would be more helpful or beneficial is giving a relaxation in terms of getting trade licenses or shops and establishment, or freedom to work from anywhere, including home or garage. Now, listing in SEBI is really not a very welcome exemption or relaxation which is there, but still the norms have been made easier for startups. Relaxation in disclosure requirements have been given. In delisting or takeover, in case of takeover of a startup by any other company or delisting from the stock exchange, your various advantages have been given to entities who deal with IPR, biotech, and nanotech activities. Like we discussed at the time of getting tax exemption, also Indranil talked about the body, which is the interministerial board. They are clearly persons from various science and background, various bioanalytics background, biotech backgrounds, who would look into the activities of a startup and take a judgment as to whether any tax exemption would be given or not. So if you are actually a startup who is into such sort of activities, a relaxation is given, and while you want to delist or any other company is taking you over. Now, minimum application size has to be 10 lakhs initially for listing on stock exchange. And these are the relaxations which SEBI has to offer for a startup.
And of course, as some of you would know, that there are now specific, startup or MSME listing related benefits that the SEBI is trying to bring in. The stock exchanges are now actually encouraging startups to list and not just go for funding from venture capital funds or angel investors, but also to go for also to try and do a initial public offer and raise money from the public. But again, there are practical challenges, like Zahir briefly touched upon. For a company which is just setting itself up, and for which still does not have enough revenue to be able to convince institutional investors to invest in their company through a public offer and be able to get the same kind of valuation which VCs are willing to offer is probably unlikely, which is why the SEBI listing regulations only have marginal benefits for most startups, but it is a benefit which is being provided nonetheless.
So next up is there have been some relaxed norms for public procurement which have been given for MSME sector. As we all know, on and from April 2012, there is this requirement of under order that a total 20% of procurement which is done by various government bodies and CPUs, SPUs have to be made from MSME sector. That sort of gives you a definite opportunity of business to MSMEs. Now, however, there will be also certain relaxations in terms of prior experience or prior turnover requirements which are there. So ministries and departments, including PSUs, have been asked to make those norms relaxed for MSMEs, but there will be no quality or standards. There will be no relaxation in terms of quality and standards of technical parameters.
And what we have been progressively hearing is that this is obviously not a benefit which has just come up now. It has been a benefit, like Zahid pointed out, which has been in place for the last 4 years, where 20% of the procurements by public sector undertakings now have to happen from MSMEs, and there are specific norms, relaxation of norms that are given to them. So they do not have to typically, for most of the, tenders that are floated by these public sector undertakings, there is a minimum revenue threshold, there is a minimum number of years of experience that are required, and they have been relaxed. But because there is no relaxation in the quality or standards or technical parameters, and also because there is a very strong competition, and because there is a large amount of due diligence that a PSU does before it has a vendor onboarded, most MSMEs have not been able to get a lot of benefit out of this. There are some who have, but most haven't, and many public sector undertakings are actually struggling, and they have not been able to get that 20% procurement which is now mandated from the MSMEs. But this is something which goes beyond. So this is here the term which is being used is really micro, small, and medium enterprises, which is defined under the MSME Act. So this is not just for the startups as defined under the Startup India policy of 2016, but this is for the larger community of MSMEs, including manufacturing companies which have been in business for much longer periods of time than what is prescribed under the Startup India policy.
Again, the RBI, the next benefit which has been provided to startups is incoming of foreign capital. There are certain relaxations which have been provided by RBI. Now, the startups have been allowed to receive foreign venture capital funding by enabling them to transfer the funds from other residents or non-residents. Relevant amendments have been made to FEMA regulations in this regard, and in order to fund your company, now an Indian startup having an overseas subsidiary can open a foreign currency account in a foreign nation, wherefrom the money which has gone into that account by export done by the Indian startup or sales done by the overseas subsidiary can can be repatriated into the Indian account within a period of 9 months, which is actually the period given under a separate FEMA regulation for realizing export proceeds. Again, another benefit is that any payment for exports and sales, which is to be done by the Indian startup or the overseas subsidiary, can be directly credited as foreign exchange into an exchange earners foreign account, which is opened with an Indian bank. In case of outward remittance, some other some important relaxation is that Form 2 can be now filed online. Now, again, simplifying the procedure of reporting the FDI transaction by making the transaction-wise, the penalties have now been specified in the regulation itself. Now, for accepting payment on behalf of overseas subsidiary, these are again certain relaxations. While opening up, as I mentioned, you can open foreign currency account abroad to pool your foreign exchange earnings from as foreign subsidiaries. Relaxation in terms of that period I talked about, you can repatriate that amount within a period of 9 months, which is actually the period which is given for realizing export proceeds, which is made to a foreign country. Now, facility in terms of starting up any startup and realizing receivables from overseas subsidiaries have been given through online payment gateway services is up to 10,000 USD currently, which might be revised by the RBI at a subsequent time. Now, another aspect of getting yourself registered is one, of course, your product or your service has to be innovative in nature. The other aspect is it should be eligible to get patented under the laws, patent IPR laws. Now, there is a scheme which has been floated by the government in order to address the following objectives. The first one being to promote commercialization of intellectual property with ease. Now, there is a fast patent application process which has been brought into place for faster processing of the application made before the patent office. There has been a rebate in fees which has been allowed. Facility of an imbalanced facilitators have been set up to give advice on your IPR requirements, who will be present for consulting by various startups. However, such consulting will not lead to transfer of IPR rights to the government or even to the facilitator. They will also be attending the hearing on your behalf, and they will see through the process of your patent application till the end.
And this is something which, if it's used properly, can be of great value to startups, because many startups struggle to protect their intellectual property rights. Especially technology-driven startups, which are coming up with innovative, products and ideas, often do not know what can be patented, for what copyright can be claimed, how they can protect the trademark, or if there is a specific design innovation that they're bringing in, how to protect the design under the various intellectual property laws. What the government has said is that they've identified and defined a set of people as facilitators, and actually called upon lawyers and patent agents and people like that to apply to become facilitators as a part of the scheme. And what they're saying is that you can, if you are a startup registered under the Startup India program, you can actually go and seek benefits from these facilitators. And the facilitators will support you through the entire journey, as Zahid was pointing out, of advising on what kind of intellectual property protection you should go for, to the actual filing of the protection, and helping you through the process if there is any dispute, etc., that comes up. And for all of this, there is a fixed fee that a facilitator will get from the government as a part of the scheme, and the startups themselves will not have to pay anything to the facilitators. this will most certainly be of great benefit for innovation driven companies, which is what is being promoted through the Startup India initiative. And if used properly, and if the right kind of organizations volunteer to register themselves as facilitators, it is something that is likely to benefit the startup community significantly, and can most certainly be considered as an incentive for companies to be setting up business here.
Under the Companies Act 2013, which we know came up much prior to the notification of the announcement of Startup India initiative and the notification which even came later. But however, there are certain provisions which are there in the Companies Act, which a startup, if it forms like a one-person company and a private company formed as a one-person company, it can start with a paid-up capital of 1 lakh, which is a minimum single promoter may incorporate. So it can be incorporated with a minimum paid-up capital of 1 lakh. Small company, if it goes for a small company, now paid up share capital can be less than 50 lakhs or a turnover less than 2 crores. That is again an option which is there in startup, which can in Companies Act 2013, which can be explored by startups. Dormant companies, in case of so basically they are companies which do not have any financial transactions, is another type of company which is there in the new Companies Act 2013. CSR activity, if we talk about corporate social responsibility activity, now contributing to incubators notified as eligible spending under, these have been anything which is getting a sum which is getting contributed to incubators which are notified are eligible to
so this is actually Zahir, a very interesting benefit if you consider it from the point of view of large enterprises. They are now being encouraged to set up incubators as innovation centers and support centers for the startup ecosystem, and the contribution that they're making towards the setting up of incubators will be considered as contribution that they have to make as a part of their CSR initiative. And this, if we consider, and we are aware that a lot of large organizations, including the likes of Microsoft, etc., have already started setting up incubators under this scheme, because it is the CSR initiative that is now required to be taken by companies above a certain revenue threshold under the new Companies Act. If setting up of incubators can be considered a part of those activities, it does open up a new thought for these organizations, and especially for people who are in businesses which require technological innovation in large amounts. For example, in green tech, in healthcare, in software technology, this can be an interesting way of developing the startup ecosystem, which is something that the Companies Act of 2013 is trying to promote.
Right. Plus, there is this application through which you can register, incorporate a company within a day, which is another possibility of getting yourself registered as a company by using the application. So now this slide gives you a perspective. We have included this. This is a slide aimed at the MSME Act.
When we did the presentation for setting up compliance systems for MSMEs, which was our first session under this series of webinars, one of the questions that came up from one of the participants in the webinar was, can we also know some more about the benefits that are available for MSMEs under the MSME Act? So we thought we will incorporate this as a part of that, and so Zahir, you can
Sure.
talk about.
So basically, at the top we are so there are certain thresholds within which you can fall under, register yourself basically as a micro, small, or medium enterprise. So if you are into manufacturing, your investment in plant and machinery, if it's less than 25 lakhs, you are a micro. You can opt for a micro, register yourself as a micro entity under the MSME code. Next, if you are into services, again, the investment in equipment has to be less than 10 lakhs. For small entities, the investment in plant and machinery, if you are into manufacturing, will be between 25 lakhs to 5 crores. And similarly for services, it will be between 10 lakhs to 2 crores. For a medium entity, the investment, if you're into manufacturing, the investment in plant and machinery will be, I think, between 5 crores to 10 crores. And if you're into services industry, your investment in equipment will be between 2 to 5 crores. Now, only thing which needs to be kept in mind here is while calculating this investment part is that for plant and machinery, the cost of pollution control, R&D which you do with your products or machineries, industrial safety devices which you implant in your factory, in your plant, will not be, these all cannot contribute towards as your investment in your plant and machinery. They will remain out. These shall be excluded. If you look at compliances, so the law basically lays down compliances for MSME sector, entities which are registered as either micro, medium, or small entities, and for people who are transacting with registered MSMEs. For MSMEs, there is a requirement of filing of memorandum, which has to be filed with the state government to set up their enterprise. This is a one-time compliance, just like registration under any other law. Now, again, there is a registration under Udyog Aadhaar, which is required to be obtained, and an Udyog Aadhaar number will be given to all MSMEs. And there is an online registration facility for this as well. Furnishing information on an ongoing basis by all MSMEs with regard to their Udyog Aadhaar number, the plant capacity, their investment, all product manufactured, etc., have to be filed from time to time. For buyers from MSME, as many of us know, the law lays down that there is a period limit up to which you can keep payments which are to be made to any MSME. That is 45 days. You will have to make all payments of goods and services received from registered MSMEs within 45 days. And if you don't do that, the law lays down compound interest, which is payable at the rate of 3 times, which is the prevailing bank rate which the RBI has come up with. Additional information which one needs to provide who is a company who is availing goods and services from a registered MSME are the amount of outstanding of principal amount which is there, which remains to be paid to MSMEs, the interest amount which is due, the amount which is paid as interest along with the amount paid after the due date or prior to the due date, and for the succeeding years also. So the details of any sum, since the law lays down there is a penalty, time frame in fact for paying out dues for MSMEs, and also a penalty if you don't pay. It kind of asks for information with regard to what is the amount, both from a principal amount perspective as well as the interest which remains outstanding and which needs to be paid to MSMEs.
So essentially, as far as the MSME Act is concerned, the point to be noted is that the most credible and the important benefit is that 45-day payment. What we, as people who are working closely with the MSME sector, what we often hear is that larger enterprises are not willing to pay within the 45-day period or find other ways. For example, we were in a discussion with an interior decorator the other day, and she was mentioning how large enterprises inevitably, after 15 to 20 days of their invoice having been raised, find some issue or the other with the work and then ask them to redo some parts just to be able to get over the 45-day requirement. So while this is a benefit in the generic sense, the fact of the matter is that in many cases the real benefit of this is not received. What we have also heard from some of the MSME colleagues of ours in manufacturing businesses is that if they insist on the 45-day payment, a lot of the larger organizations then do not even consider them when the next opportunity to work together comes up. So those are the kind of shortcomings of this enactment. Of course, the other issue that is there is with regard to this whole thing of identifying who's a micro, small, or a medium enterprise by virtue of their investment in plant, machinery, or equipment. Uh, it is quite possible that in today's day and age that a lot of the plant and machinery is not actually invested in terms of actual real purchase. Many times, today, for example, services organizations lease or rent a lot of their equipment which they require on an ongoing basis, which could be mostly servers and computers and things like that. And therefore, the actual investment, even for companies with much higher revenue than what is probably envisaged under the MSME Act, can take benefits. What is recommended by at various forums is a more revenue and profit-driven approach to definition of MSME Act, which would probably help in getting some of the the current anomalies in the law clarified. There are also additional benefits that could probably be considered for the MSME Act to be to find more teeth and get more acceptance within India. So that is broadly what we had to say. We have already introduced who we are and about our solution Complify, which is a specific compliance solution for MSMEs, which has all sorts of compliances under central, state, and municipal laws, including tax and labor and environment, health, and safety. We'd be very happy to take any questions that you have. And Mr. Rao, I would like to hand over to you now for opening up the session for questions.
Sure. Thank you so much, Mr.